Bonjour à tous et bienvenue pour ce nouveau webinaire de SurrogateFirst. Donc aujourd'hui, nous avons l'invité Stanley Brenner, qui était un avocat américain qui travaille en Floride. Il va s'introduire, mais aujourd'hui, on va étudier ensemble les démarches légales aux États-Unis pour les parents français. Donc, de la GPA, bien sûr. Donc, welcome, Stan. Thank you so much for joining the webinar. I will be, putting subtitles. This is for French intended parents, so it's really for our French friends that you have worked with for many years. So, Stan, go ahead, introduce yourself. Tell us a little bit more about you, and then we'll go ahead.
So my name is Stan Brenner, and I've been practicing reproductive law for many years, as you can tell by my white hair. And for over 30 years, it's been my passion to help people have families. That's what I'm all about. I like to help people have families. I'm an attorney, and I have an office in Florida. And we've worked with many clients from France. We love working with our French intended parents, and have worked with Maxine and SurrogateFirst. And I'm here to go over the laws of surrogacy in Florida specifically, and otherwise in general.
Beautiful. All right. Thank you so much. So I'm going to share a little presentation I made. It's going to be pretty simple, pretty quick. We just get an overview of the whole journey. So first of all, what we're going to do is that, once again, up. There we go. So what we're going to do, I'm going to share my document, and there we go. So les démarches légales de la GPA aux États-Unis. Bien sûr, pour tous les Français qui sont sur ce webinaire, je vais mettre les sous-titres en français quand on parle anglais. Okay, so I will put subtitles in French, of course. So we're going to review through this journey, through this webinar, we're going to review the surrogacy law by state. We're going to just take a look at surrogacy law map, and of course talk about more Florida, because Stan is a Florida attorney, so get the idea of what happens in Florida. We'll talk about the gestational surrogacy agreement, and then a brief overview of the different papers needed, the different steps needed for your child before birth and after birth, pre-birth order, post-birth order, and the birth certificate, and of course passports. So surrogacy laws can be confusing, especially because there are no federal laws regulating surrogacy in the United States. State surrogacy laws significantly shape the legal surrogacy process for intended parents and surrogates alike. Some states are considered to be completely surrogacy friendly, meaning they either have statuses permitting and recognizing surrogacy, or they have a long history of favorable rulings in surrogacy cases. On the opposite end of the spectrum are non-surrogacy friendly states. These states generally do not recognize or enforce surrogacy contracts and have statuses or published case law prohibiting compensated surrogacy. It is important to meet with an attorney in the state your surrogacy will be living and giving birth before starting anything. So Stan is here to tell us a little bit more about those laws, specifically in Florida. He can give us an overview of the other states. I will show the map, okay? And then he can go ahead and review the law in Florida and how it works. So first, my question is Florida a surrogacy-friendly state? Can you tell us a little bit more about that?
Absolutely. Florida is a very surrogacy-friendly state. In fact, I don't know if you knew this, Max, but Florida has had a surrogacy statute since 1993. We were one of the first states to enact a surrogacy statute. So we are very surrogacy friendly in that we can work with all types of intended parents. We can work with married intended parents. We can work with single intended parents. We can work with gay intended parents. We can work with intended parents where there's no genetic connection to the child. So it's a very surrogacy friendly state. And we're looking at a map of surrogacy laws by state. Now, I'm licensed in Florida, but we work with intended parents all over internationally and in other states as well. And if there's 50 states, there's 50 different provisions and laws dealing with surrogacy. Like Max said, some states actually have surrogacy statutes. Other states have case law that dictate how to proceed in a surrogacy matter. And in some states, and I see they're highlighted in red over here on the surrogacy map, it's prohibited and you want to avoid them at all costs.
Exactly.
So it is important to consult with an attorney at the beginning of your journey so that you know if the state that your surrogate is located in is a surrogate-friendly state or not.
Beautiful. And so you have worked with quite a bit. I mean, Stanley, I've been in the field for 7 years. We've been working, together for a long time, trying to educate. Every time I need people to, an attorney to educate my French parents, I usually call you. So you've worked with a lot of French intended parents. Do you want to tell us a little bit more about your experience? You said that, you work with many different kind of couples, right? Single, heterosexual, homosexual. So tell us a little bit more about,
So I'll speak for Florida specifically in this case, in that one of the reasons Florida is favorable for intended parents is that as long as the surrogate does not have any genetic connection to the child, she doesn't have any rights to the child. So that's really important. Now, obviously, in every case, there needs to be a surrogacy agreement. Max, tell me if I'm getting ahead of myself.
Yeah, no, it's perfect. You're doing a little opening for the next page. It's perfect. So
there needs to be a surrogacy agreement entered into between the intended parents and the surrogate. And both parties to the agreement need to have their own independent attorney representing them. That's at the basis. And so I've been doing this for a long time, and it came to me not within the last couple of years as to why we need these agreements. And I was thinking about it, and obviously we have a law in Florida that dictates that you need to have a surrogacy agreement. But other than that, I've come to the reasoning is that in an ordinary situation, a woman who is pregnant is carrying her own baby. That's a typical situation. Someone's pregnant and they're carrying their own baby. In a surrogacy situation, someone is pregnant and they're carrying someone else's baby. And the surrogacy contract navigates the distinction between it's the surrogate's pregnancy, but it's the intended parent's baby.
Baby, right.
So we have this extensive agreement that navigates the difference between her pregnancy and the intended parent's baby. And I understood it better that way once I came to the realization that that's why we have to have these agreements. Because if it's her baby and her pregnancy, there's no reason for an agreement.
Okay. So talking about the agreement, we can move forward to the next page. And so talk about this agreement, this gestational surrogacy agreement, GSA. A gestational surrogacy agreement is an agreement between intended parents and gestational carrier and her partner/spouse, if any. These contracts can be compensated or uncompensated and are intended parents to detail the parties' rights, obligation, intentions, and expectation in connection with their arrangement. A comprehensive GSA always covers the parental rights and custody of the child, location of delivery, health insurance, other insurance obligations, payments of medical bills, all kind of different things that will, like Stan said, kind of give you the guidelines and the directions of the whole journey. So do you want to tell us, what is usually on an agreement? I listed some things here, but what are the terms that usually are added, and where do you find those terms?
So the agreement is very comprehensive. We cover a lot of different topics and issues and things that could possibly arise during a surrogacy journey. But to go through, and even when I do a consultation with intended parents who I'm working with, we can't go over every little detail because it's too extensive. So I think, obviously, from an intended parent standpoint, you want your surrogate to take care of herself, to eat healthy, don't do anything that would jeopardize her health or the health of the baby. That's obvious.
Right.
So we talk extensively about that. And that's something that's, it's common sense and it's understood, but you need to go into detail in the agreement.
Exactly.
Some other issues that we talk about are how many embryos are going to be transferred. Most clinics these days are strongly advising that one embryo be transferred, but on occasion we do work with situations where 2 embryos are transferred.
Right.
Rarely have I seen more than 2 embryos transferred these days.
Thankfully.
Thankfully.
And so what about so you have all those terms of the surrogacy agreement. Have you ever seen any issue past that? Any enforceable, like, have you ever enforced or see parents enforce an agreement because there was a breach of contract? Is that something that happens often?
Fortunately, it doesn't happen often. As I said, I've been doing this for a long time, and luckily, have never had a situation that it's elevated or escalated to the point where someone had to go to use the legal system to enforce a provision of the agreement. And one of the things that I found out, and this is not something that's legal in nature, this is something that I've kind of learned over the years.
Your experience.
Through experience, is one of the aspects of a whole surrogacy journey is maintaining good and open communication with your surrogate. If you have open communication with your surrogate and maintain lines of communication, if issues come up during the surrogacy process, they usually are resolved very easily and amicably. It's the times where I've seen things blow up and become an issue is where communication between the intended parents and the surrogate breaks down.
Right. That is, yep, go ahead.
And as part of that, the agency also can play a role in fostering communication between the parties as well. So I would say, do issues come up? Yes. Do they come up often? Not really. They don't come up often. If things are done properly at the beginning, you find that there's less issues that come up during the process. And what do I mean by properly at the beginning? Well, you have an agency that you're working with who hopefully is going to screen the surrogate and make sure that they at least qualify for being surrogates from not even a medical standpoint, just from a social standpoint.
Exactly.
And then obviously you're going to have a psychological evaluation of your surrogate. You're going to have a medical evaluation of your surrogate. So it's not someone who's walking off the street, as I spoke to someone about yesterday, and says, I want to be a surrogate, and all of a sudden they find themselves matched with intended parents. If it's done properly, it doesn't work that way. There's an extensive review process that takes place before the match is even made.
Right. To bounce off what you just said, surrogacy, it's such a complex journey that involves so many pieces that we take care as an agency at Trinity Clinic, take care of the 2 most important things for people, their babies and their money. It's a long, expensive journey. It's really emotional. It involves your child. The smallest little issue can turn, it's a snowball effect. So the smallest little issue can turn into a bigger issue later. So that's why Stan is so right. I'll say communication is key between your agency, between your surrogate, or anybody. If there's any doubt, any concerns, it needs to be talked about and addressed before it turns into a bigger issue and before the communication and the trust is broken. So that's something that is really important, and I'm glad that Stan talked about it. Another thing that is on the agreement, and we'll talk about that because we know the US, different state, is the abortion law, right? In the US, the Roe v. Wade, 1 or 2 years ago, was over, how did they do exactly? What did they do exactly? They overrode the law, the law, they canceled the law, or what? They kind of what did they do exactly? And so the law for abortion is now per state. It's not federal anymore. It's like the states decide on. So tell me a little bit more about GSA terms of abortion on the GSA and the law in the US / Florida, because you're in Florida. How did that, you know?
Yeah, since the Supreme Court of the United States overturned the prior ruling of Roe versus Wade, which gave women the right to an abortion on a federal level. It was a federal right that women had to control their own bodies and destiny and determine their reproductive health.
Right.
The current Supreme Court decided to overturn that law, and now it's up to each state individually to come up with their own laws regarding termination of a pregnancy. Mm-hmm. And so it's really important to know what that law is in the state where your surrogate is located.
Right.
And it's also important to make sure that the issue is addressed thoroughly in the gestational surrogacy agreement.
Right.
Now, I can tell you that while it's a really important issue and needs to be thoroughly addressed, mm-hmm. it rarely comes up in a surrogacy journey.
Exactly.
And so much so that I've been doing this for a long time, as I've said over and over again. But
good, we know now that you are experienced.
but in all the years, I have yet to have, and I hope it doesn't happen, a case where we have had to have a surrogate terminate the pregnancy.
Right.
So the fact that, you know, I've done so many and it's never occurred doesn't mean that it doesn't need to be addressed, because if it does occur, it's a big deal. It's a big deal.
We know what we need to do. We know what we agreed on. What is the next step? Yeah.
Right. So each state has different laws. Sometimes in a particular state, if the state's law is restrictive and only would permit a termination of pregnancy very early on in the pregnancy, in some cases, in case of a non-surrogacy arrangement, some of these state laws are so restrictive that, you know, women don't even realize they're pregnant.
Right.
And they can't, if they wanted to, if there's a problem, they can't terminate the pregnancy because it's too far along already, which could be like 6 weeks. So we want to make sure that your surrogate and you are on the same page when it comes to this issue. It's really important that the surrogate and the intended parents be on the same page.
Right. Okay.
I like to see a surrogate that says, listen, this is not my baby. This is your baby. I will defer to your wishes. Right. And if she's in a state where the termination of pregnancy laws are restrictive, we want her to agree that if termination is necessary and required, that she will travel to a more abortion or termination friendly state in order to do the procedure.
Beautiful. Okay. So there are options. So even though, you know, abortion is not legal or restricted, or, you know, I know some states are a lot, you know, strict than others. Texas is, I think, one of the strictest states regarding abortion. So there are all kind of different laws. At the end of the day, agreement or no agreement, it's really up to you and your surrogate to see how you feel, if you're on the same page, and then if there were to be any issues, which are rare and rarely you know, occur, but if it happens, then in this case you guys can arrange travels to another state and everything like that. Okay, beautiful. So you know, we talk about GSA. This is the legal step in the middle of the journey before she is able to get pregnant. Then, you know, after legal clearance, once we're done with the GSA, we go into a transfer, right? The next step is transfers, medication and transfer. And then she's pregnant, hopefully pregnant. So the next steps after that, we'll talk about, and this is going to be the last point we're going to touch on, but it's basically all the different steps after or during the pregnancy and after birth, which are the pre-birth order, post-birth order, and birth certificate, and of course the passport. But usually passports, parents do that on their own. Attorneys help with pre-birth order, post-birth order, and birth certificate. So a birth certificate, a birth order state that the surrogate mother will give up all legal rights to the child after he or she is born. Once a pre-birth order is in place, the hospital will also be required to put the intended parent's name on the baby's birth certificate, eliminating the need to file more paperwork after birth. Do you want to tell us a bit more about pre-birth order? And is there a pre-birth order or anything similar to pre-birth order in Florida?
So some states, as Maxime had said, are pre-birth order states. And in the pre-birth order states, you can establish your parental rights by virtue of having a pre-birth order. And when the child is born, you will be recognized immediately and placed on the birth certificate from birth.
Okay.
And some states are pre-birth order states.
Okay.
Florida happens to be a post-birth order state. In Florida, in order to get your name on a birth certificate, you have to have a post-birth order. In Florida, it's called an affirmation of parental status. And this takes place very shortly after the baby's born. It's an expedited proceeding and takes place within a few days, up to 3 days after the baby's born. However, I can speak for Florida, and my practice is, even though Florida is a post-birth order state, we, in all cases, get a pre-birth order as well. Now, the pre-birth order in Florida does not get the intended parents' names on a birth certificate. The pre-birth order in Florida is mainly for the hospital. It tells the hospital that the intended parents and surrogate entered into a binding and enforceable surrogacy agreement, that the intended parents are the parents and are going to make all decisions for the baby from the moment of birth, that when the baby's ready to be discharged from the hospital, the baby gets discharged directly to the intended parents. And there's an original birth certificate in Florida, and the intended parents can name the baby with their last name on the original birth certificate that's generated at the hospital. The only thing that the pre-birth order in Florida does not do is it does not get intended parents' names on a birth certificate. Right. And so in order to do that, like I said before, we go and we get the post-birth order and get the intended parent's name on a birth certificate through a post-birth order.
Beautiful. Okay, so a post-birth order is similar to a pre-birth order. Expect that it is obtained after the birth instead of prior to the birth. And the post-birth parentage order also establishes the intended parents as the child's only legal parents and orders them placed on the child's birth certificate. So this is kind of like what you just said, is the post-birth order will place the names of the parents on the birth certificate.
Correct.
Okay. For the birth certificate, what I said is the intended parent's name will be on the birth certificate. Usually it is created, so depending on the state, obviously that's what you mentioned, but usually it is created right after birth. Basically, how does it work? I know they receive it 10 days, depending on the state, usually 10 days after birth. 7 to 10 days is the birth certificate that is received by the parents. What happened before those 7 to 10 days, right after birth? How does that work? Can you tell us a little bit more? How does it work?
Well, the intended parents are the parents. Okay. I can tell you in Florida that the intended parents are the parents, even though we don't have a post-birth order yet, they're their parents. Okay. The post-birth order is a legal document that recognizes their parentage. And so even without the birth certificate, they are the legal parents of the child. The intended parents are the legal parents of the child.
Okay. Beautiful.
And Max, as Max said, post-birth order, I would say, at least in Florida, we have our post-birth orders within 10 business days of birth, usually.
The birth certificate, correct?
The birth certificate. And it looks like any other birth certificate. It doesn't say surrogacy or anything else on it. It looks like it's an ordinary birth certificate, just as if you had given birth yourself.
Right. Okay. And then usually after that is the passport for the French parents to go back to France or to their country, wherever they're from. But what happens is that once you get the birth certificate, you are able to then apply for a passport, correct? So there's the birth certificate that you need a check, a money order check, you need a picture, you need a form that is filled out. So there's few things to do, and then everything is sent to the passport agency that will help with your passport. And so there are different ways to create your passport, to get your passport. There are expedited services, so faster or long. It takes, usually it takes 3 weeks, 2 to 4 weeks. How long does it take in Florida to get your passport once you applied?
It's really not a Florida matter.
Okay.
The passport is a federal matter.
Okay.
So some intended parents that we work with like to take matters into their own hand, and they will go down to the passport office. Florida, it's in Miami, and apply for the passport themselves. In order to do that now, I believe you have to show that you have travel plans within a certain amount of time in order to get an appointment to get an expedited passport through the passport service.
I think it's 72 hours. It's within 3 days.
I believe it's 72 hours. Other intended parents use, as Max also said, a passport expediting service, and they will basically, you will send them the birth certificate, the final order, whether it's a pre-birth order or the post-birth order, and they will basically process the passport for you. And they charge different fees depending upon the length of time that it's going to take them. So the shorter the period of time, the higher the fee generally.
Okay.
But usually they can get you a passport within a week.
Okay, so it can be pretty quick if you're in a hurry, or it can take longer. If you're not in a hurry, you don't want to pay as much, you have time, you want to spend time in the US with your baby, get the breast milk or anything, and just take your time over there, you could do that as well. Okay, beautiful. So this is kind of all I wanted to talk about. It was a brief overview on the different laws in the US, especially in Florida, the gestational surrogacy agreement, and all the different orders for your baby. Stan, do you want to add anything? And what makes, maybe my last question for you is, why Florida, right? Especially for French parents, like, why Florida? Tell us.
Well, we have a great climate. It's warm. You don't have to deal with snow. It's really easy to travel from France to Florida. We have Disney World, we have Miami, we have the Seaquarium. We have a lot going on in addition to our weather. Plus, we have very favorable surrogacy laws.
There you go.
And
you have Stan and Max. I am in Florida, so you are both of us in Florida, which is a big
that
deal.
Goes without saying, of course.
That's awesome. Okay. Well, thank you so much, Stan, for your time. I'll have you, I'm sure, in the next webinar, probably with a French attorney. I wanted to do that today, but it was a little early. Next time, we'll try to get Fabien Joly on the call, and we can kind of bounce idea of what is the best ways to bring your child back, and the different papers, and kind of like what matters for French parents. Okay? Really? Okay. Thank you, Stan. Thank you, Stan.
Merci beaucoup, Maxime.
Merci beaucoup. That was a pleasure. Merci à tous, en tout cas, pour avoir regardé ce webinaire. Thank you, Stanley Brenner, again for joining us, and we'll talk to each other soon. Have a good day. Bye. Thank you so much. Bye.
Bye.